Board of Supervisors to order, please. The first item on the agenda is the Pledge of Allegiance. Please remain standing. Following the Pledge of Allegiance will be a silent moment of reflection. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We will have the reading of the notice, please.
An educational meeting of the Marathon County Board of Supervisors will be held at the Marathon County Courthouse, Assembly Room, 500 4th Street, Wausau, at 6 p.m. on Thursday, March 19th. The agenda was duly signed and posted.
Thank you. I would like to request everyone silence their cell phones and any other electronic devices as to not be an interruption to the meeting, and I thank you for your compliance. We will move on to roll call and ask all the supervisors to please sign in. Thank you. We have 7 supervisors joining us by WebEx, and 4 supervisors were excused. And so we'll move on. I'd like to welcome all of the visitors that we have with us this evening, and we have a full room, and thank you for your interest in county government. We will move on to item number 7 on the agenda, and that is public comment. Not to exceed 15 minutes. We have had 5 people sign up for public comment, and each will be given 3 minutes of time. And please address your comments to the chair. And if someone else already expressed your opinion on the topic, please concur. Again, we will have 3 minutes for each individual. The first individual that signed up is Cindy Nielsen. And please come up, state your municipality, and then 3 minutes will be given to you.
Good evening. Thank you for letting me talk. My name is Cindy Nelson. I live in Stratford in Eau Plaine Township. I just wanted to make a few comments. I come up all the time. I have been going house to house to be informing people about the wind turbine projects that are going on in Marathon County. I have gone to about 200 houses. Most people are kind of familiar with the project from what it was a few years ago. They don't realize what is going on this year. They're looking for information. My house is located right in the middle of the project, as is new subdivisions that are going in Stratford are literally right there across the street. They have no idea what is going on. Nobody wants the wind turbines. Out of the 200 people that I have spoken to, they don't want the county board making decisions for them because they have no information. They don't want the townships. They do not want turbines at all in their area. Most of them have lived there for a very, very long time. They don't want the substations. They don't want anything to do with these projects. So I really ask that you really think about what is being talked about, maybe sending out some information. I have been giving them some information from Farmland First, but nobody is for it, not one person. I have not met one person who wants anything to do with wind turbines. They don't want it near their house, in the area, where it's super close to Marshfield. It's going to affect the industrial park in Stratford as far as internet. And it honestly is still, Lynn Farms still wants 3 of the largest ones in the field right behind my house, and the setback is 1,250 feet. I have only lived there 8 months, and I am going to fight this tooth and nail. Thank you, and have a nice evening.
Thank you. Next, we have Wendy Rogowski.
I'm from Green Valley.
Thank you.
So good evening, and thank you for allowing me to speak tonight. I'm here tonight to express concern about language in the current comprehensive plan draft. Last week at the public hearing, I asked that more time be taken to strengthen this plan, especially regarding industrial scale energy facilities. I urge this board to vote no next week on advancing it in its current form and send it back for revisions. Hopefully, these revisions will include some of the items I forwarded to Supervisor Dickinson. Tonight, I want to focus on one issue, the use of the term wind, solar, and battery farm. It may sound harmless, but words matter. In a document that guides land use and zoning, words shape decisions. Calling these projects farms is very misleading. Farms are tied to crops, livestock, and family agriculture. That is not what's being proposed. These are industrial-scale energy facilities. They include massive turbines with equally massive concrete foundations, thousands of acres of solar panels, substations, battery storage, transmission lines, access roads, and ongoing industrial activity. This is not agriculture. It is industrial development. Using the word farm blurs that reality, and it has consequences. It shapes perception. People hear farm and assume something compatible with rural life. It affects policy. Labeling something as agriculture can open the door to more favorable treatment in areas meant to protect farmland. And it creates confusion. This plan should be clear and honest about our land use. Industrial energy development should be identified as industrial, period. Have you ever heard of a factory called a manufacturing farm? And we don't call power plants energy farms. So why are we doing it here? If this county is serious about protecting farmland and supporting farmers, then accurate language matters. Replace wind farm with something like industrial wind energy development, and please do the same for solar and battery facilities throughout the plan. Please call these projects what they are, industrial, and plan accordingly. Thank you.
Thank you. Next, we have Barb Newton. Barb.
Good evening, and thank you, Village of Rib Mountain. I'm here to discuss or reiterate what we talked about a couple of weeks ago at the meeting about the reduction of the speed limit on double end and also no passing. We did have 75 residents sign the petition in favor of the speed reduction. It is a community where you have a lot of people that walk, ride their bikes, and we have a lot of businesses there with in and out traffic. We have the ski hill, we have restaurants, we have many businesses, but it's also a community. We have the ski hill, we have a big problem with the people turning into the ski hill and turning out of ski hill. I myself live just off of the subdivision west of the golf course, Boulder Ridge. And I have on 2 occasions very narrowly missed a head-on collision turning east while somebody was passing going west. And that's pretty much all I want to say right now. And like I said, I'm just reiterating what we talked about 2 weeks ago. Thank you.
Thank you. Next, we have Heidi Pesky, I'm sorry, Heidi, please.
Okay. Hi, I'm Heidi Pesky. I'm from the town of McMillan. A joint development agreement is not required for a county to review, regulate, or respond to a utility scale wind project. Counties already possess the tools they need, such as ordinances, zoning authority, and participation in the PSC processes. I did a Google search on a lot of the negatives, and I found a dozen that I thought were important. We'll see how many I can get through. Commits the county to support, facilitate, or not oppose the project in PSC or local processes, which undermines the county neutrality in the PSC proceedings, creates appearance of bias towards the developer, prevents the county from updating zoning, road use, or health and safety ordinances for the duration of the project. Locks the county into outdated standards for 30 to 50 years, since these are what the contracts are, conflicts with the county's duties under Wisconsin statute 59.54 and 59.69, prevents the adaptation to new science, noise standards, or safety information, requires the county to allow heavy haul traffic, widen roads, or permit oversized roads. The risk is road damage costs often exceed reimbursement. The county may be responsible for long-term maintenance under Wisconsin statute 83.015. Disputes over pre-existing condition are common and costly. Often written to protect developer, not the county. The county may assume liability for accidents, nuisance claims, or emergency response costs, and the insurance provisions may be insufficient for unenforceable after ownership changes. Restricts what the county can disclose or say publicly about the project, which reduces transparency and public trust, limits the county's ability to communicate openly with their residents. Offers annual payments tied to megawatts, milestones, and community benefits. Payments cannot exceed statutory utility structure for Wisconsin statute 76.28. It creates unrealistic expectations for schools and other taxing jurisdictions. Schools receive nothing. No JDA can change that. And construction jobs are temporary, if few, while the long-term operation jobs are minimal. Developer agrees to consult with the county on turbine placement, and the county may appear responsible for citing decisions that it can't actually influence. Requires disputes to be resolved through arbitration or developer-friendly processes. It limits the county's ability to enforce ordinances. Arbitration can be costly and confidential. Locks the county in obligations for the life of the project, which binds future boards and administrators, prevents policy updates for decades, creates long-term political and legal exposure. Often vague or tied to future financial assurances. Decommissioning costs can exceed over $500,000 per turbine.
30 seconds.
Oh, okay. Financial assurances may be inadequate or eroded by inflation. The county agrees to coordinate emergency services for turbine incidents. The fire, rescue, and EMC costs fall on local taxpayers. Turbines, fires, and blade failures require specialized responses. JDAs rarely include long-term funding for emergency services. So please look into closely the JDA agreements. I think that we can cover it versus your zoning, versus our ordinances, and versus the PSC. And so we can protect all of our residents.
Time. Thank you. Next, we have Cindy Hogan.
Evening, Cindy Hogan, also from the Village of Red Mountain. I just wanted to say I was one of the 75 people that signed the petition in favor of reducing the speed on Double N. I'm also in favor of that being a no passing zone. I want to thank the Infrastructure Committee for forwarding this recommendation on to the county board, and I look forward to each of you voting to keep Red Mountain safer. Thank you.
Thank you. That concludes the individuals that have signed up for public comment. And we will now proceed on the agenda. And I would ask that we take the standing committee designees and chairs reports out of order unless there is objection by the board, and move on to item number 8B, a presentation on the ongoing multi-district litigation regarding PFAS substances and the opportunity for Marathon County to engage in counsel to join the litigation. I turn it over to the administrator first.
Thank you, Mr. Chair. I'll be brief. I know I say that a lot, but this time I really mean it. I'll invite up counsel from Atolis Law, and I'll let Attorney Phillips introduce any other individuals that will be speaking to provide information to the board. My understanding is we should have someone appearing virtual, and they will talk through this topic. I don't know, Andy, if you want to.
Thank you, Mr. Chair and Mr. Administrator. I'm wearing a couple of different hats tonight, and so it's a pleasure seeing you all again. I've seen you all several times, and tonight I'm wearing the hat, first off, of Atolis Law as it relates to this litigation. And so we're going to talk about the opportunity for Marathon County to join in the effort to hold manufacturers of these forever chemicals responsible for potential cleanup. Tonight's the opportunity to hear a discussion from the nationwide council that we work with regularly, that deals with these issues every day, that represents public agencies just like Marathon County all around the country, and you can ask those questions to get the information you need. I can tell you that personally, this issue dropped on my radar at Atolis Law when we started looking at things like Assembly Bill 130 and Assembly Bill 131 that spoke to this concept of innocent landowner exceptions to the spills laws. The spills laws essentially allow DNR to come in and force property owners to clean up contaminated property. I know that I am paraphrasing, and Mr. Robinson's going to have something to say about my paraphrasing at some point, but that's essentially what the spills laws do. And so in dealing with these forever chemicals, it's been a challenge as a state to figure out what do we do with them. And so in Assembly Bill 131, there was the creation of these innocent landowner exceptions. Counties are not included with blanket immunity from the spills laws. And that concerned me, and it ought to concern you to say, well, at some point, somebody might knock on our door and suggest that we have to do something about these forever chemicals. And so we started looking at what was happening around the country with the litigation surrounding responsibility for cleanup, for remediation, for identification, for investigation, and so on. So that's when we started the conversation with Carrie McDougall of the Barron and Budd Law Firm. I'm very familiar with that firm, worked with them for many years on a variety of issues, but they are one of the leaders in the country in terms of the litigation effort. And so I believe that Carrie is online. I don't know. He's online. I'll let him do his own speaking when he gets that opportunity. But I wanted to also just reinforce the fact that this is your opportunity to ask all sorts of questions. And I know I've seen in advance a lot of very good questions that came from various board members, so feel free to ask those questions. Second on the agenda, 8C, is going to be a discussion of renewable energy regulation. That's when I put on the Counties Association hat. I and the Atolis team are privileged to serve as general counsel for the Wisconsin Counties Association. And the regulation of renewable energy projects is something very important all around the state. And so WCA wanted to ensure that this board had all of the latest and greatest information as it relates to a county's authority to regulate these renewable projects. As Atolis Law, we represent several counties around the state in the negotiation of joint development agreements. But as counsel for WCA, our role is to educate all of the county members as to a county's appropriate role in regulation. And then finally, I cannot wait for the closed session because I have some things to say about your administrator. That's a separate issue, all right? And I want to make that clear. So we'll start with the forever chemical litigation, and I don't know if Kerry has anything that he wants to say in terms of introductory comments, but I want to be clear that the floor is the board's in terms of asking those questions. So Kerry, is there anything that you wanted to address?
Andy, can you hear me first of all?
Yes, we can. Thank you.
Okay, perfect. I apologize for the awkwardness of the remote Zoom. Let me just introduce myself and what we are doing with regard to this litigation and just kind of set the framework to give you a frame of reference as to what is ongoing, what is the history of the chemical lawsuit, and currently what is the status of it. So let me give you a very, very abbreviated version of the litigation, if that's okay. About 6 years ago, we filed the first, what I'm going to call PFAS case in the country. And that was for a county similar to yourself that had PFAS contamination in its water system. A little bit different than I think, what you all are looking at this point. But 5.5, 6 years ago, that was filed. And at that point, the knowledge of PFAS and the extent of the science with regard to PFAS and the regulatory world with regard to PFAS was extremely limited. That has greatly, dramatically changed over the years. It's evolved with the science and with the knowledge about the chemical, about, we didn't even know it's a forever chemical 6 years ago, but we do now. We now know the levels that are of concern. We know the contamination that is a potential there, both now and in the future. So we know much more about the chemical. Based upon that knowledge, when I say a number, hundreds of other municipalities, cities, counties, some school districts, and the states have initiated actions after ours. There are a handful of law firms. We are frankly the lead counsel, jointly co-lead counsel in this case. Once that many cases are filed about a single issue, such as PFAS, the federal court system has a vehicle to manage that volume of cases. And it's a management tool where the federal court system can go and convert it to a multi-district litigation. That's called an MDL. The theory behind an MDL is we take all of those cases, put them with one judge, as opposed to the various hundreds of various venues that they're filed in throughout the country. They're consolidated into one judge and one court for management purposes. That was done about 5 years ago, given the volume of cases. The case was consolidated in Charleston, South Carolina, before Judge Richard Gergel. As lawyers, it can always be a mixed bag when you're dealing with an MDL, because you file the lawsuit in your local venue that you know about and you're comfortable with. Once it's converted to an MDL, frankly, you're subject to the federal judge that is appointed to oversee the litigation. This is no exception. We have been beyond pleased with both the MDL, with Judge Gergel's management of it, his guidance to bringing some order to literally at this point thousands of cases that are pending related to PFAS, and that's quite a management task. He's done a superb job. So this case has proceeded. The judge, as part of his management tool, had to say, all right, I've got thousands of these cases, thousands of litigants, different types of claims. How am I going to bring order to that? His approach to the litigation was this. He determined that the public water systems, that is, the public water providers throughout the country that had confirmed PFAS contamination, their cases would be segregated and rise to the top. The theory behind that was the EPA was becoming increasingly regulatory with regard to water standards and levels of PFAS. So you had a situation where, I'm just going to use this hypothetically, Long Beach, California. If Long Beach had PFAS in their wells that exceeded the regulatory limits, they would have to take that water well offline, jeopardizing the access to public water. So the judge thought the public water aspect was the most important to take first. I think he was right on that, by the way. I'm drastically oversimplifying. Once he determined that the public water systems cases were going to go first, he opened up discovery. What I mean by that is the exchange of information that free flows in lawsuits. And that is the information that the plaintiffs give defendants, the defendants give plaintiffs. These cases are, as Andy mentioned, product liability claims. They are never against the local industry that may have helped contaminate, if you will. They're never against anyone other than the chemical manufacturers that created the chemical in the first place. The documents that we have obtained through that discovery process reveal that these chemical manufacturers knew for decades, and I literally mean decades, the potential for PFAS to contaminate and the potential for it to be, in fact, there forever. Those documents also show that those facts were hidden from the public and from the regulatory bodies, including the federal government, over years. So that free flow of information against the product manufacturers and no one else, and there are roughly, I can't remember how many there are roughly probably 14 defendants, all chemical manufacturers that produced PFAS, that created it. However, the primary chemical manufacturers in the case, if you were to allocate who manufactured what over what time frame, it would be Dow Chemical and DuPont. Excuse me, I misspoke. 3M and DuPont. They have manufactured the vast majority of PFAS throughout the country. In the water cases, and I'll get to the types of cases that you all will be concerned about in just 1 second. In the water cases, hundreds of depositions were taken. Experts, untold sums and numbers of experts on all sides to litigate the case. The hard work that brought that about also brought about a settlement in the water cases. It was the largest settlement in the history of toxic torts in this country. 3M paid the bulk of it, and it was roughly, I'm rounding, roughly 12 to 13 billion dollars. And DuPont paid, can't remember the exact amount, but $3 to $5 billion. Now, there are other remaining defendants in the case that are also have liability and have paid some sums of money. Not all, but some have done that. The result of that is this. Judge Gergel has approved a massive settlement on behalf of the water providers in this MDL litigation. So now that those are largely, not completely, but largely disposed of through that settlement, what's up next? Judge Gergel at that point said, all right, I'm going to bring in now the personal injury claims. He did that roughly 1.5 years ago. He is litigating those as we speak. He does that by establishing what we call bellwether cases. Those are just sample cases. Instead of taking 10,000 people and bringing him into the courtroom, he said, all right, parties, plaintiffs, defendants, you all choose your 10 best, if you will. And I think that's what he will do on the remaining types of cases that we have. So right now, the current status is water provider settlement, massive. Number 2, what's up now are the personal injury cases. There are settlement discussions ongoing now. I can't tell you what will happen from those. They're proceeding, I think, efficiently and very well. So the question then comes, what's next? I don't know the answer to that. Only Judge Gergel will know the answer to that. But what I can tell you is the airport claims, the soil-based claims that were excluded from the water settlement, I think have the potential to be the next cases. That would include cases such as Marathon counties. So that is a background on the history of the litigation, where we are in it. Judge Gergel has appointed my partner, Scott Summey, as lead counsel for all of the settlement discussions. He is the architect, frankly, of the massive settlement that was done and will be the lead person for any subsequent settlements. And he's also appointed my law firm co-lead counsel for the various law firms that are represented in terms of their cases. So that's a history. That's kind of the status of the case itself. We can talk as you direct me, and I'm gonna let you all lead it as to what questions I can answer, either about the issues I've already covered or about what Marathon County can do and what its legal options are now. Now, that having been said, and I'm going to turn it over back to Andy, that having been said, I am always hesitant, just to be blunt, in a public forum to discuss legal matters. So I will be cautious, just to be blunt, on what I say and the topics that I cover. But I think what I've said so far, those are all matters of public record and public information. I think that's fair. So if I'm hesitant in answering, it may be because probably those are better left for closed session. So anyway, I'll turn it back over to Andy.
Yes. Thank you, Carrie, for that explanation. I should have introduced Evan prior to introducing Carrie. Evan Kladitis is my partner with Atolis Law, and he has been working with several other counties around the state to answer questions and provide information relative to this litigation and what it means to any particular county. So I wanted you to be able to put a face with the name Evan Kladitis. He is here as well to answer questions and otherwise make me look smart. So good luck.
Try my best.
Mr. Chair, I'll leave it to you how we proceed.
So we'll open it up to questions. I know there's been several questions that have been submitted by various supervisors around this topic, but I'll open it up for questions that you have for either council. Supervisor Robinson, please.
Wow.
Surprise.
I'm shocked.
Well, welcome to Wausau,
Yes.
the place where all 6 of their municipal wells were impacted by PFAS, and the community's invested millions of dollars in treating it. But my questions deal with the scope of, in the terms of the settlement, in the context that we, as a county, are facing issues with PFAS. I think the airport, where the FAA mandated the use of it in fighting aircraft fires and, you know, the associated training and cleaning of vehicles, probably isn't the smallest share of the exposure that the county has, but nonetheless, there may be a limited exposure. But in the context of our landfill, where we're a passive receiver, receiving everybody's waste that breaks down, the products break down, but the chemicals don't. So my concern is that as we look at that and we look at our use as a purchaser of equipment, will the provisions of any of the settlements in the MDL restrict our ability to recover from those same companies in other litigation? So if we deal with AFFF foam, if we deal with personal injury, will it limit our ability to recover our costs associated with the reverse osmosis and treatment and destruction at the landfill, or other instances where we may have exposure?
I don't know if Carrie, if you want to address that in the context
Yeah.
of the overall claims and
Happy to.
potential settlement, go ahead.
You bet. Here's what we do not know. What we do not know is what the terms of the release will be about a future settlement. Let me speak to the water settlement that was done, the big one. The settlement, the release language will be critical to answer your question, which we don't know yet. But the release language in the water settlement specifically excluded claims that municipalities might have with regard to airports, wastewater, landfills, sewage systems, et cetera. There are a number of specific exclusions that were part of that, recognizing that folks like in Marathon County and others may have claims that is unrelated to water contamination, yet may be contaminating soils or landfills. So that exclusion allows you all at this point to have a claim and have a cause of action against these defendants. And I would frankly urge you to take advantage of that. What will the settlement language in the future look like with regard to these type of claims? Let me say hypothetically. Let's just say Marathon filed a claim for PFAS contamination for its airport, its wastewater, et cetera. I would assume, but I can't tell you and guarantee, that any settlement provisions, first of all, any settlement provisions you would have to agree to, by the way, you wouldn't be mandated. But any settlement provisions would tie us back specifically to the source of the problem, such as in the water release, it tied back to PFAS in water. And I would hope that a future release will also tie back for an airport, for example, to PFAS contamination that emanates from an airport and the soil surrounding it. That's what I think will happen. Can't guarantee it. I hope that answers your question, but that's kind of my best estimate at this point.
Supervisor Lemmer, please.
Thank you, Mr. Chair. So I'm not sure if my question was answered or not because I'm still confused. Is this lawsuit just for, or this settlement just for the airport, or does it go into our landfill and then just, I guess, related to that, or maybe not? Do we know anything about the amount that we would get? And would this, you know, if the standards are 4.0 right now, is that enough to cover the costs of any repairs that we have, especially if we have to put the landfill in that settlement?
Before I allow Carrie to address the question of what's included in the soils claims, so to speak, so for everybody's edification, just this week, the legislature adopted legislation lowering that standard of 4 parts per trillion where it was much higher. In other words, it's much easier to find contamination, if you will, because contamination is defined as a lower threshold of these forever chemicals in the soil. So I think that, in my mind, is a signal to me saying, we're going to have to do something about this based on that. But then I will allow Carrie and Evan to expand on what claims, so to speak, are included that we're talking about tonight.
Carrie.
Evan, do you want to, I'm happy to start if you'd like, or you tell me.
Sure, go ahead.
Okay. First of all, let me make sure everyone understands that there is no settlement. There has only been one settlement so far, and that's for the water claims. There is no settlement for the soil or airport claims that we're talking about now. That will be the subject of many different municipalities throughout the country filing lawsuits to recover for damages for the treatment of that soil and the removal and remediation of it. So it's a hypothetical settlement. To get a settlement, you got to file a lawsuit, though. So let's just assume that Marathon files or initiates litigation for, let's just say, soil contamination, airport, firefighting foam, wastewater. The scope of that lawsuit would depend upon discussions that we would have with you all in terms of what you have found about contamination, the levels of it. We know that the airport, well, I say we know, I think we're pretty darn certain that the airport has impacted soil. Any airports that had any fire training facilities or had firefighting foam, and they almost all did, it's going to be somewhere. So you're going to have a legal claim based upon that. It's also my understanding that there are landfill issues where PFAS has been detected. You have a claim for that. And so the scope of the lawsuit will be defined by what we put in it. Right now, it's those two things, but there may be more that I'm unaware of. So that would be the scope of the lawsuit. Going to your question, what about a settlement, a hypothetical settlement in the future? If we file a lawsuit, will it make us whole? Will it cover the expenses and costs related to what we're trying to do to remedy the problem? I can tell you that I've done this 30 plus years now, and there has never been in environmental litigation of this magnitude a situation where everyone in the country is made 100% whole. I can tell you we come as close as we possibly can. Our goal is to make you 100% whole. And let's just, I'm throwing out numbers. This is just a little hypothetical number. Let's just assume hypothetically that it costs you all $1 million to put a treatment system in, to remediate, et cetera, et cetera. We know it's going to be significantly more than that, but let's just say $1 million. Can I guarantee that you'll recover that $1 million in the litigation? I can't, obviously. Any of the lawyer that would do that, you need to question them. But what I can tell you is that for the water providers, the cases that have been settled so far, if they were not made whole, most of them are grateful that they got significant funds to fund their treatment systems in whole or in part. Because the ultimate objective here is to make sure that the Marathon County public and taxpayers don't shoulder the financial burden for something that was created by a chemical company and is their fault and something that they should shoulder. And so the litigation's goal is to make you as whole as possible. But I'm not going to sit here and say that, because you're going to be one among many others in this case. I mean, you're going to have your own individual case, but there will be many others. I think my firm represents many others that have cases just like yours. And so I don't know that everyone's going to be made whole. I don't know. It's going to depend upon the levels of contamination you have, which I don't think we know for sure. The costs associated with treating it, both now and in the future. What you're going to try to do is, and what we will work hard to make sure you get, is you need to recover the costs associated with current treatment of the problem. Now, how that problem is defined is going to be airport, wastewater, et cetera. Current treatment of the problem, but that's not it. It also needs to include future treatment, because whether it's reverse osmosis or other treatment modalities, there are going to be future costs for maintenance, for O&M related to those systems, various other future costs. You want to recover that as well. In addition, frankly, you want to recover your attorney's fees. So that is the process by which we will try to make you whole. No guarantees on that, but I can promise you it's better to participate and get the maximum recovery from these chemical companies as opposed to nothing. But I think we can do way better than that. So anyway, I hope that answers your question, and I apologize if it didn't.
Carrie, this is Evan. Would you comment as to whether there's a minimum threshold when it comes to these soil cases?
There's not. There was a misperception in the water cases that you had to have a certain level of contamination in your water to have a claim. The judge quickly said, nope, that's not the case. If you have any levels of PFAS in your soil, even without knowing the testing results, I can tell you that that's going to likely be the case. If you have any levels, minimum levels even, you have a claim that can be pursued against the chemical companies in the MDL. Now, that having been said, if the extent of your contamination is less than, let's just say the city of New York is in this case, and they have massive contamination throughout Manhattan, obviously the scope of that's going to be a little bit bigger than Marathon or Green Bay or others, because of the size and probably the levels of contamination. So the ultimate payments on this are going to vary based upon the extent that each individual plaintiff or claimant has about their contamination. And I don't know what that is at this point. There's no minimum level, though.
Okay, next we have John Robinson again, and then we have Vice Chair Dickinson on deck.
So the state of Michigan, their Department of Agriculture and their University Extension System this week and next week is doing a series of 1-hour webinars on PFAS in agriculture, and today was on croplands and others. One of the concerns that I have is when we look at the issue of the town of Stella in Oneida County, where the very significant levels of contamination, do we as a county have the ability to include in our claim the potential impact to areas where land spreading occurred in order to make those property owners whole through either the treatment of the groundwater and or containment of the soil? And can we look beyond our corporate entity as a county into our responsibility as a county under the state statutes to protect the health and welfare of citizens? Can we include that in our claim? And given, again, when we go back to the city of Wausau had PFAS in their water supply, which means PFAS were in their wastewater supply. That PFAS in the wastewater supply was discharged to the Wisconsin River and captured in sludge that was land spread throughout the area. So there's a likelihood that many people in this county are impacted in one way or another by PFAS through the land spreading of that material.
Before Carrie jumps in, let me just address this briefly from a toxic tort litigation standpoint. That means that you have to have an injury unique to you to have a claim. We're not talking about an on behalf of, or sometimes it's referred to as a parents patria type lawsuit where we are suing on behalf of these other entities. We're not. We're talking about a claim unique to Marathon County. And so unless Marathon County can prove injury unique to Marathon County, it's not going to have a claim. But I will say that the goal in this litigation, and I think Carrie can correct me if I'm wrong, but the goal here is to give you complete freedom as to how you would use the proceeds, whether it be through litigation or settlement. If you want to distribute those to others, that's up to Marathon County. That's a policy decision that this board makes. And we want to give you the flexibility to utilize those dollars as best you see fit. So there would be nothing prohibiting you from engaging in some sort of remuneration to others impacted. You don't have to do that, and that's not our legal claim. Our legal claim is we have been injured as Marathon County because of these chemicals at our airport, at our wastewater treatment facility, at our landfill, and so on. But again, if the money comes in, if it does, and you want to share those proceeds, that's up to you. And I don't know if, Carrie, you have further comments on that.
You answered it very, very well. There will be no restriction on the designation of any settlement proceeds. In fact, it would be inappropriate for Andy and I to even involve ourselves in that. How you all that's a local the autonomy of the local governing board. You all will make the decision what you do with it. I've had situations in the past, frankly, at some point having nothing to do with PFAS and other cases where we got significant recoveries for a major environmental catastrophe and the city did not use it for handling that catastrophe. That's a local political issue. I would not want to be in their shoes. But the bottom line is there's flexibility for the governing authority to determine how and where those funds are allocated.
With the opioid litigation? Oh, I see what okay, so your administrator brought up a very good point. There are parallels that we draw with this litigation, which is an MDL, and the opioid litigation that I know this county is also engaged in because I represent this county in the opioid litigation. And if you remember, there is a state statute and a settlement agreement governing use of settlement proceeds from the opioid litigation. We have to use all of the settlement proceeds to combat the opioid epidemic. It's called approved uses in the settlement agreement, and the state statute says you have to use it consistent with those approved uses. What Carrie is discussing, what I'm discussing, what Evan is discussing is there would be no schedule of approved uses associated with any sort of settlement or litigation victory that generates revenue to this county. That's what we're talking about. So there is a big distinction between what happens in the opioid litigation and what occurred there and what we're dealing with here. Now, I say all of that because I started this discussion with a concern that at some point, the Department of Natural Resources might say, you've got to do something about this, okay? Doing something about this means we spend money. You heard Carrie talk about this, you'll hear me talk about this. It's not right that we place a burden on the back of the taxpayers if we have the ability to go get funding from another source to take care of the problem or do something, as DNR would put it. And so what we're talking about here is creating an opportunity for the county to get third-party funding to deal with an issue that we all see coming. How you do that, what money you devote to that, who you distribute it to, that's why you all get the big bucks.
Next up, we have Vice Chair Dickinson.
Thank you, Mr. Chair. I just want to make a comment, being the director of, or the chair of the airport board, and speaking with Brian Griefer, our airport director, we haven't had any issues with PFAS. There was one spill that was handled when we transitioned to F3 foam, and there was no issue with that detected. We have no known contamination currently. So I just want people to have just a general feeling that what the airport is doing on this issue is in line with what's happening in the federal agencies. And I think when we say airport, there might be this fear that somehow what's happening at the airport is, this great issue, and it's not. Thank you.
If I could just comment, Mr. Chair, I don't want anybody to leave this meeting thinking that we think the airport did anything wrong. We don't think that whatsoever. I don't want anybody leaving this meeting thinking that we know that these forever chemicals are spread all across airport property. We frankly don't know. That's why we need to do testing. And if the testing shows that there's nothing there, there's no claim, okay? But we know based on experience, based upon the literally hundreds of airports we've dealt with across the country, that typically there will be those forever chemicals there. Again, through no fault of the airport, but because those chemicals got into the soil. So just want to make sure that that's absolutely clear.
Okay, so
and that's fine. And I just want to be clear myself. And I understand you're a lawyer and where you're coming from, but at the same time, I think it's fair to position the other side. Thank you.
Supervisor Robinson, please.
My third and final question, because I'm limited.
Promise?
Well, I have a lot more.
Prohibited
but,
from speaking again.
You know, as we look at this, the issue of PFAS, and I serve on the DNR's PFAS External Advisory Committee, and I lead their cost work group. And so we've been trying to get our handle on what those costs are. We just don't know. One of the reasons is we're still early in the process of dealing with PFAS. The focus has been on the public water supply systems, not on rural water supply. We're just getting into the issue of wastewater treatment. We're just getting into the issue of biosolids. Do you have an inventory that counties can look at to strengthen our claim that we should go through and try to identify where our potential exposure is? And so we can put a range so that when we get into that competition with New York, that we can elevate ours because we've been more thorough relative to the identification of our losses.
I think when it comes to the airport, and Carrie can maybe comment as well, I think a couple locations will be tested. So it's going to come down to where the testing occurs and how many times you want to test. I don't think that this should turn into we're just going to do hundreds of tests all over Marathon County. We're going to try to be, of course, as exact as we can. Carrie,
Evan's right. Yeah, Evan is correct. What will happen is once, I mean, we've got to do our due diligence before any formal legal claim is filed. And part of that due diligence is to do some testing, preliminary testing. And that would be of the soils in and around the areas that we've talked about. And what I suspect you will find, I cannot comment on the levels, obviously have no idea, but I strongly believe you will find there to be a presence of PFAS, the levels of which I don't know. But the laboratories will tell us. The experts will tell us. And it will be experts retained by us, their job to look at both the soil analysis, the water analysis, the various testing that is done to come up with a model, if you will, to determine, all right, here's what we're seeing contamination-wise. Here's the scope of it. What will it take to treat that particular level of contamination and wherever it might be? So that's how you come up with this. There will be ultimately a damage model. Every client will have one, whether it be the city of New York or Marathon County, will have, because it's tied specifically to your contamination, not anyone else's. And one thing I want to say, Mr. Dickinson was exactly right. We don't know the extent of contamination. I can predict for you that there's going to be, but there needs to be due diligence performed to make sure that we do know those answers. And if the soil results come back with PFAS in the soil, we want to know how much, we want to know where, and that will dictate the experts' opinions on what will it cost to clean it up and get it out of there.
Okay, Supervisor Marash, please.
Thank you, Mr. Chair. So in looking at your legal services agreement, and for the supervisors, it starts on page 128 of the packet. On page 129, it talks about your compensation. Could you explain a little bit more, just in a way that most of us can understand, what it would cost for the county to get involved in this? Thank you.
You bet. Absolutely. This is all that my law firm we just represent cities and counties and states and environmental catastrophes. There is no county, whether it be New York or Marathon County or any other in the country, that has the budget that would allow them to retain attorneys at, frankly, $1,000, $1,200 an hour, and the army that it takes to maintain this kind of massive litigation. Multiple millions of dollars would it take. There's no budget around Los Angeles, New York, or otherwise that has that. Every case that we have taken, we have done on a contingent fee basis. And what you're looking at, what you're referring to, that is a contingent fee contract. by design. And that is, what it means is this, that if and only if there is a legal, whether that be by jury verdict or a settlement, do we get paid. Hypothetically, in this case, we've already survived significant onslaught from the defendants over the years and survived it very well. But what if the judge had thrown this case out of court? There's a mechanism called a summary judgment. They filed many of them to dismiss the case. What if that were to happen? If that were to happen, then there would be no recovery and you would owe us nothing. So the financial risk is ours. We've got to make sure we lock the case, frankly, and feel good about it. That's why we're careful and judicious in what cases we take, because we're going to be funding it. So we only get paid if there's a recovery. In addition, what about, I can't explain enough the Herculean efforts expense-wise it takes to fund these cases through experts, et cetera. It's crazy. We fund all of that. We advance all of that. Now, if there is a recovery at some point, then that contingent fee provision would kick in. We would be paid back the contingent fee that is reflected in the contract, and we would be paid back the expenses that we have advanced toward the litigation. That's the means of compensation. So it is triggered by a legal recovery, settlement, or jury verdict. That's the only time that we, frankly, get paid. And if that happens, the percentage in the contract kicks in. Does that answer your question, at least? Makes sense?
Yes, it makes sense. Thank you. And so just to reiterate, 25% contingency fee in this contract, and then you also said you would charge us for expenses, correct?
Any expenses that are incurred for advancing the case, we fund. And then if there's a recovery, we would get those back. Absolutely.
Thank you.
Other questions?
You bet.
Other questions, or Andy, did you want to?
No. That's good.
Okay. Supervisor Seibert.
One thing, let me add this. If you don't mind, can I add one thing?
Please, Kerry.
This is really a benefit of the MDL. And like I said, as a lawyer, there have been many times when I have just moaned and groaned about an MDL. But boy, I tell you what, it is efficient in terms of when you have large numbers of claimants, such as yourself. Because what happens is, what you could not do financially standing alone, you can do with 500 other municipalities. Because what happens is those expenses are shared and they are dispersed among multiple claimants. So no one has the ultimate burden to fund and move this case forward on their own. Their expenses that are shared and dispersed in such an amount that it's very efficient, so that you're not just shouldering these massive burdens, financial burdens. Now, the only exception, the exception to that would be if we have an expert for you specifically. For example, an expert that would be testifying about Marathon's contamination. That would be what we're calling a client-specific expense, and that would not be dispersed because it's based upon your specific case. But the vast majority of experts and the costs in this litigation are going to be shared expenses. Anyway, that's a benefit of the MDL.
Okay, Supervisor Seibert's next.
Thank you, Chairman Gibbs. I have a question on wastewater and how sludge is associated with wastewater. Sludge has been spread in Marathon County for as long as I can remember. And if it's traced back that the sludge that's been spread in Marathon County is the reason for their high PFAS in their wells, how do you attack that situation, or any place in the county where sludge has been spread that is impossible to clean up?
Yeah. And I'll let Kerry jump in, but I want to make clear here that there's not a claim against the spreader, the entity that may have produced the sludge or anything like that. We're talking about a claim against the original manufacturers of these chemicals. And so I want to separate out what we would typically think in our minds the responsible party to be. When we think about responsible party, it's the person who made the bad stuff and the person who spread the bad stuff. We're not dealing in this case with the person who spread the bad stuff. We're dealing with the entities that made the bad stuff. And so, Kerry, I don't know if you want to put a finer point on the question.
And I'll be honest with you on the sludge issue, and that is not something that I am. I mean, it's going to be part of this litigation. It has not been at the forefront, and that's just not something at this point I feel intelligent enough to speak on. And frankly, I would need to talk to the experts that can really understand that issue and what is the scope of what can be done for it. I just don't know, to be honest with you. So I need to be honest on that issue.
Other questions by the board? Any more online questions? Andy, you want to wrap it up then and bring us full circle?
So we have, I know, a resolution on the agenda tonight for discussion and potential action next week. If you have any questions about this, please talk to your board chair, administrator, and corporation counsel. We're happy to address any additional questions that you may have about the litigation, about the legislation that was recently adopted, the impact of the legislation on the litigation, and so on. Supervisor Robinson knows a lot more about this than I do, and so to the extent he can't answer, I'm happy to answer, and we can get you the information you need to, again, make an informed decision on this.
Okay, one last call from any of the board members. Any questions? If not, thank you, and we will proceed with our agenda. And the next is, you might as well stay right in the appropriate spot. So the next is a presentation from Atollas Law on the regulatory authority of Wisconsin counties with respects to wind and the solar energy systems and the tools available to protect county interests. And we are joined by additional counsel from Atollas Law, Rebecca Roker.
You can never have too many lawyers from Atollas at any meeting. That's what I always say. All right, I'm putting on my Counties Association hat for a moment. I mentioned at the beginning that the Counties Association is very interested in ensuring that counties understand their role in the regulatory process as it relates to these large-scale renewable energy systems. And in the discussions that we have had for the past couple of years about these large-scale systems, I think it always is interesting to think about how we got here and why we're here. And so I want to set the table a little bit for what my partner Rebecca is going to talk about here in a moment. And if you look at the energy grid in Wisconsin, we're pretty fortunate. We've got a good grid, especially in comparison to some other states. But what we've seen over the last 20 years is the capacity of that grid diminished. Why? We've got all sorts of efficiencies now that we didn't have 20 years ago, and those efficiencies have led to less demand for power. And so when you have less demand for power, you've got utilities that are going to ramp down in their power production. We've seen the closure of various facilities all around the state. And so right now we sit in a position where our consumption is commensurate with what's being produced, and what's being produced now is a lot less than what was being produced 20 years ago. What's happened recently that impacts that grid? What's happened? Data centers. Data centers. One data center can account for more than 1% of total energy usage in the state. I already talked about how our grid has diminished capacity to supply. And so we've got a grid that's lower in capacity. We have plants that have been taken offline, and we have an increased demand for power because of these data centers. And so we've seen a lot of entities turn to renewable resources to supply energy to the grid. When I talk about renewable resources, wind and solar. At the same time that we've seen entities turn toward wind and solar projects to provide power to the grid, we have seen the state step in and say, we view this as a matter of statewide concern because we're dealing with our state of Wisconsin grid, and so we want to make sure that there's uniform regulation throughout the state. So what used to be a nice little local control mechanism is not a local control mechanism anymore. And Rebecca's going to get into some detail about that. So again, the Counties Association is very interested in ensuring that counties understand the role of counties in that regulatory system and process. I can tell you, in addition to our work with the Counties Association, we've had the privilege of working with several counties all around the state on the negotiation of joint development agreements and assessing certain issues that arise in those counties as it relates to these renewable projects, and we're going to hopefully leverage all of that experience for your benefit here tonight. And I'm going to sit down in a moment and let Rebecca talk because she's the expert. She leads the negotiation team in our firm on these joint development agreements. But again, ask questions if you have questions. We're happy to answer them. So Rebecca, I'll turn it over to you.
it okay if I stand down here? Okay. Can everyone hear me okay? It's just easier to see the board up there. Good evening, everyone. I've had the privilege of meeting many of you at different WCA conferences, but I've never had a chance to visit Marathon County before, so it's great to be here. Andy, thank you so much for the introduction. He really hit on the point of how we got here. And so let's just dive right in. There are some sections, particularly some of the legal intricacies, that I will kind of go over quickly because I want to be respectful of everyone's time. So if you have questions, Mr. Chairman, I don't know if you want to take questions at the end or if you want to as they go.
Whichever you prefer.
Okay, we'll see how it goes.
Yeah.
All right. Okay, so we're going to talk briefly about the projects that have been proposed or we think may be proposed in Marathon County. And then we'll talk a little bit about preemption and this, very high-level statement that counties don't have any control for any renewable energy project that is over 100 megawatts. We'll talk about that. Then I want to touch briefly on the PSC process, because the PSC process in Wisconsin is like no other process from a legal standpoint that we have. It's very unique, and so it's very important to understand what the PSC is doing and what role the county may play in that. And then we'll talk about the impact of those, the state law and the PSC process on what's happening in the county. And then most importantly, what are your options? That's really what we want to talk about tonight. And we want to make sure, and WCA wants to make sure that everyone here understands what options you may have as you move forward in light of the projects that are being proposed for your community. Okay, so you may all know this far more in depth than I do, but in preparing for our trip here, I tried to find as much information on the Hub City Wind project from Alliant Energy as possible. Surprisingly, there is nothing yet specifically on file with PSC. Now, that doesn't mean that they haven't been doing a whole lot of work. I know they send out newsletters and they send out other information. I know that they have what they call host properties. They've entered into land agreements, leases for private owner properties. So they've definitely been doing a lot of work. But again, interestingly, there hasn't been anything specifically filed at PSC. So here we've just got a snapshot of what the project is as we know it right now. This, of course, is subject to change, and until they file something at PSC, it's kind of a moving target. There are, again, no engineering plans filed at PSC, and engineering plans are very important because that is the first step prior to seeing an actual application in front of PSC. So there's not even engineering plans filed yet. I did make a note here, there was a docket opened for some of the GenTie agreements, which, given how our grid and how our network is connected, you'll see agreements like this. So they relate to the project, but it's not a project proposal. The EDP Renewables and Marathon Wind LLC, I'm sure many of you are familiar with that. Many across the state are, because the town of Brighton case is really an extraordinary case. The town of Brighton ordinance and the arguments that the town of Brighton brought forward were very compelling arguments. And the circuit court upheld the town of Brighton's ordinance. That did go to the Court of Appeals by a declaratory judgment, or a request for a declaratory judgment, or that was appealed to the Court of Appeals. And then the EDP Renewables dismissed that at the Court of Appeals, which from a geeky lawyer standpoint, we found fascinating just because of the language of that circuit court appeal. Well, then we found out that the Marathon Wind project has been purchased as part of the Hub City project. And that explains why EDP, Marathon Wind LLC, dismissed that lawsuit. So a lot of different factors going on. And again, I'm sure all of you live this, and so you have more information than you may want to have. But the town of Brighton case really does bring a unique element to what we're talking about tonight. All right, and then we have the Invenergy, I always say that wrong, the Stonemark Wind Energy Center. There's a lot of unknowns with this one. We know that it's going to be big, but footprint, specific project area, all of those particulars, not even particulars, but the generalizations of what's this project footprint going to look like. We don't know any of that, or a timeline. So that one is also on the horizon. Now, I had heard, in an earlier public comment at a different meeting, that there is a solar project that is also being proposed within Marathon County. And in my search of the PSC dockets, there was no current filings, and there's no highlighted cases on the PSC website. The PSC is very proud of the number of renewable energy projects that have been approved, which we'll talk about in more detail. And so they will have highlighted cases of very large renewable energy projects. And there's none on there yet for Marathon County. So the one thing I did note was a transmission line CPCN request for the North Central Wisconsin Reliability Project. I suspect that that is going to be interconnected with all of these different projects, so that that was one thing that caught my attention in just looking through the PSC docket as it applies to Marathon County. So let's talk about your ordinances. You do have section 17.405 is the wind energy system ordinance. You have that on your books, and I know that you're looking ahead to a potential the comprehensive revision to the zoning code. So this may be affected. And your ordinance applies to both small wind energy systems and large wind energy systems within that particular definition of a capacity of 300 kilowatts or more. Your ordinance specifically says that any system with a capacity of greater than 100 megawatts, the ordinance does not apply. And that's the magic number you'll hear us talk about tonight, is that 100 megawatt. That is the threshold where PSC's jurisdiction is triggered, and one would say local jurisdiction is depleted. It's that 100 megawatt. So, in your ordinance, there is that bright line of anything over 100 megawatt. But interestingly, when I look at your ordinance, I do see elements that may be able to be used as points of discussion, if you will, in future conversations. So that's just something to keep in mind. All right, let's talk about the PSC process. Again, it is a very unique, very complicated process. First step is always the filing of the engineering reports. This is like a kind of a preliminary report that is filed with the PSC. I should be clear too, the PSC is the Public Service Commission of Wisconsin, and that is the administrative body that has jurisdiction over public utilities, energy generation, et cetera. And so once the application for a CPCN, it's a Certificate of Public Convenience and Necessity. I always have to pause. The CPCN, a CPCN is required under the statutes in order to construct and operate a renewable energy facility of 100 megawatts or more. So you'll hear me talk about a CPCN application. That's the application for the project. And so once that application is filed at PSC, the vast majority of the project preliminary work is done, which is why we know these wind projects are happening. They're doing their due diligence, they're doing their legwork, but there's nothing filed at the PSC. So it can be a challenge when we find out about a case because of the filing at the PSC. Sometimes we're behind the 8 ball. So from your standpoint, it's actually a good thing that nothing has been filed at PSC yet, because you have time to get your ducks in a row. Okay, so the environmental review process, I don't know about you, but when I hear the term environmental review, I think of PFAS, I think of environmental contamination, I think of, traditional environmental issues. What the environmental review process is in front of PSC is we're looking at the whole environment. How does this particular project impact cultural resources, historical resources, health and welfare, physical health, neighborhoods, communities, businesses? You look at that entire environment, and then there's an analysis of how this potential project is going to impact the environment. This is where we have a joint effort between DNR and PSC, because DNR is the body that actually prepares that environmental report. And you see here I listed there's different types and levels of environmental reports. If you have a certain type of application, you will have to do a more in-depth environmental report, which is called an environmental impact statement, an EIS. I will tell you, I used to work at DOT. And when I worked at DOT, I can't think of even a minor majors project that we did not have to do an EIS for. I have not seen PSC require an EIS for any of the solar projects that it has renewed recently. So when we're talking about who is protecting the environment, PSC is not requiring EISs. They're requiring EAs. So you will get an EA, which is still a very thorough document, but it is not that deep dive into the environmental analysis that we used to see, within our state government. All right. So now let's just touch on, oh gosh, that's really small. There are provisions in the state statute, primarily in Chapter 196, that talk about what a county can do or what a municipality can do in terms of regulation. And frankly, it's very minimal. There's not a whole lot that counties can do or that is recognized within Chapter 196. The point of this slide, and really one of the points I want to be the takeaway tonight, is once that CPCN application goes to PSC and is approved, there is a statute on point and there's case law saying that the project can proceed nevertheless. No matter what happens, once you've got that CPCN approval in your hands, that project is a go. So again, from a timing standpoint, it is imperative that if the county wants to get involved in the project, it should get involved early. Now, sometimes counties do get involved later, and we can accommodate for that. But again, with these wind projects, it's a good thing that there has not been a CPCN application filing yet, so we still have time. All right. Let's jump to, okay, so this is, I'll just touch briefly on this. Many of you have probably heard this before. Andy and Evan and I talk about this at conferences. Counties can only do what we have statutory authority to do, right? All of the authority comes from Chapter 59. If there is another law on the books that is of the same topic or issue, a county regulation may be preempted. And statute 660401 is the best statute we have that gives direction on what, and I say county, but this also applies to cities, villages, and towns, what a county may have in its ordinance. So 660401 is another ordinance or another statute I'll keep referring back to. So again, I think I'll just move through this. Andy, what do you think?
No, I think that's fine.
Yeah. So basically, PSC 128 is a Wisconsin administrative code that addresses wind energy systems specifically. And so there is a host of information in PSC 128 that tells you as the county what you can and can't do to regulate. There is no equivalent of PSC 128 for solar, which is interesting, and I don't know why. So at least on a wind energy system project, we have some statutory guidance of what we can and can't regulate from an ordinance standpoint. Solar is, we're no pun intended, but we're kind of just moving in the dark because we don't have a provision such as PSC 128. Okay. Going back to 660401, because again, that is the section that you rely on to have statutory authority to adopt your wind and solar ordinances. 660401 says there's 3 instances. If these 3 restrictions are met, your ordinance can stand. Number 1, the restriction serves to preserve or protect public health and safety. So as a lawyer, I read that and I'm like, great. You know, if something is within our police power, it is, the purpose is to protect health and safety, that's great. Not so much because courts have very narrowly construed that section. And that section is not as broad in terms of giving you authority to regulate renewable energy. The second is the restriction doesn't significantly increase the cost of the system or decrease its efficiency, or the restriction allows for an alternate system of comparable cost and efficiency. The second 2 points in 660401 we'll see sometimes, but usually the point of contention is number 1. Okay. So within 660401, again, that is the only basis we have in the statute to regulate. And So the whole purpose of 660401 is to limit the ability of local communities to regulate renewable energy systems. And again, if we want to regulate, it has to fit into one of those very narrow exceptions. I'm gonna flip through this. Now we get to the Ecker Brothers case. So we've got 660401. And we could even talk about the Town of Brighton case within this analysis as well. So in Calumet County, they adopted a renewable energy ordinance, and Ecker Brothers wanted to rent their the farmlands to the renewable energy company, and their conditional use permit was denied. And Ecker Brothers sought review, and the court said, no, Calumet County, your ordinance is too broad. You are overly regulating these renewable energy systems, not according to your statutory authority. And so this quote from the Ecker Brothers case really summarizes what it is, the takeaway is. So the conditions that are used when you are regulating these renewable energy systems, and the standards of the local, the county, the local units of government, those are not doors to be opened. Those are doors with very narrow instances with which you can regulate. And so again, I always think of like a door being cracked open. The court is saying, no, this is not an opportunity for you to come in and over-regulate. Those three instances in 660401 are very narrow examples of when you can regulate. So what this case did is it really gave us some hard and fast rules of when and how counties can adopt renewable energy ordinances. Another key takeaway from the case is that the ordinance has to be not cookie cutter. It can't be a blanket regulation of all types of systems in certain specific ways. An application has to be looked at a case-by-case basis. And I know within your ordinance there is that language, that case-by-case basis language, so that's good. And then we can't have an ordinance that essentially is a one-size-fits-all. Again, the takeaway being the state legislature and the courts have interpreted 660401 in such a way that it limits your authority to regulate renewable energy systems. So now this is the important part. What are your options? So, whoops. I'm frozen. Oh.
I don't know. If I'm your IT help, you're in a world of hurt. There you go.
My throat is starting to hurt. I just popped in a cough drop. All right, let's take a little pause first and talk about whether we can stop a project. As of last November, and actually this number 33-0, the PSC's record was 33-0 in approving solar projects. It had not denied one. And since November, on March 5th, it just approved a very large solar project in one of our client counties. It is astonishing to me when the amount of information that comes in front of PSC and the pace that they whip through that information to come to a decision. And again, they're approving these at a very fast pace. So what does that tell us? It means we have to do a lot of work on the front end. So again, we're going to talk about what your different options are. But oftentimes we will hear people say, you know what, this is not fair. We should have a voice. This is our land. And all of those things are accurate. But what are the chances that it's going to make a difference? And I hate being the person up here to say that, because we all want to have our voices heard. But the way that our state law is structured is it makes it very difficult for our voices to be heard and to stop a project given what's going on in Madison right now. 33-0, these things are sailing through. Now that number relates to solar, but I'm not aware of a wind project that PSC has denied either. So I think the philosophy of renewable energy projects on a very large scale of being approved is across the board, whether it's wind or solar. I think this quote, the Silver Maple quote, this is directly from PSC's website, that this project helps us demonstrate Wisconsin's enthusiastic support for projects like this by submitting a comment in support of Silver Maple Solar. This is on PSC's website, and they're saying, hey, submit a comment in favor of this project. That is astonishing to me. Now, that being said, this project has already been approved, and they don't do comments like that as much anymore. But again, this is just a good indicator of what the trend is at PSC. When you hear about other townships or other counties, excuse me, that may have stopped a project.
Rebecca, we got some water here for you.
Oh, thank you. Thank you so much. Yeah, sorry, my throat is scratchy. I am not aware of a project being stopped due to litigation. Town of Brighton, I think, would probably be our best example that the town was successful. and it was appealed, and that appeal was dismissed, but that project is still going. And I can't imagine the time and the amount of resources the town had to put into that effort in that litigation. So just be mindful when you're considering, we're going to stop this project. Again, I hate to stand up here and say, you're not, but chances are you're not. Because of what state law tells us, what state law allows the state to do, how it preempts us as locals, and how fast PSC is approving these. So what can we do? Like, give us something here, Rebecca. Like, don't just ruin our night. What can we do? This is where Andy and I and our whole team, we look to what leverage do we have. So we look at the impacts of these renewable energy systems and how can we protect the county and the residents from those impacts by using the leverage that we have. What can we do? We can do nothing. And some counties choose to not engage because they have been told time and again by organizations that are very pro-renewable energy that you have no authority to regulate. And it's, yes, state law says 100 megawatts and over jurisdiction lies with PSC, but that does not mean that you don't have the authority or you don't have the ability to have your voice heard at the table. But certainly from a policy standpoint, you can choose to do nothing. The second choice is to negotiate a joint development agreement. Now, I've given presentations before, and some of you may have been at the WCA conference where this happened. Someone stood up and said, why would we ever negotiate a joint development agreement? Why would we ever sit at the table with those people? And I was very taken aback, and I said, because you might get something. You might get something to protect your county, your resources, and your people. And that is the whole purpose of a joint development agreement. It is not to back the project. It is not to, stand arm in arm and say, we support Alliant Energy. It is a mechanism to protect the county because chances are this project is going to happen anyway. Another option, we didn't even talk about this within the context of the PSC proceedings, is the county could choose to intervene in the PSC proceeding. By intervening, you are essentially stepping into that PSC proceeding as a party. And so you have more control, you have more say, you can submit evidence within the hearing process. And so it makes your voice louder, if you will, and you can keep a little bit better check on the proceedings themselves. It is a very complicated process. It is a very expensive process because complicated equals expense. But some counties have chose to do it. And the counties that we've had the privilege of serving who have done it have been very successful. So it's another option for you to consider. And it's also, if you look at that little chart there, it's an option that is interchangeable with negotiating a joint development agreement. You can start negotiating a joint development agreement and still keep that option open of intervening. And we have one county that we're working very closely with right now. We are in the midst of negotiating the joint development agreement, and we have a specific provision in that agreement stating the county may still intervene in the PSC proceeding once that CPCN application is filed. So please don't look at these and think that it's one or the other. Counties certainly choose to blend them, if you will. The most really expensive option is to litigate. We call this the scorched earth method. And we have had counties that have wanted to do that. Whatever you need, here are all of the resources. Andy and I love it because, okay, we'll spend your money, but it's not effective. At this point in time, we have been very effective in litigation. On the other end of a PSC proceeding, but the purpose of that litigation was to leverage that joint development agreement. So even in the context of when we are well positioned for litigation, it's not the option that we recommend for counties for many different reasons. All right, let's talk about what are the goals that we want to protect or we want to achieve. What are the impacts of these projects that we want to see memorialized in a joint development agreement? Obviously, liability. We want to make sure that the county is shielded from any liability as a result of construction, operation, or decommissioning of a project. The traditional environmental, protecting groundwater, your water bodies, wildlife corridors, and other natural resources. Noise, the shadow flicker when we're talking wind, light, the actual physical elements such as fencing, setbacks, landscaping buffers. Now, with respect to wind projects, PSC 128 does have some elements when it comes to things like setbacks or other actual siting requirements. For solar, we don't have that. But keep in mind, even though for wind projects, PSC 128 has those minimum standards, that doesn't mean that a JDA cannot exceed those. So we still have the ability to negotiate with an Alliant Energy to have more favorable restrictions than what they are permitted to do under the statutes. Roads, the use of your roads, obviously county roads and county infrastructure is a tremendous asset to the county and very expensive to repair. So we want to make sure our roads are protected. Decommissioning, when the project goes bye-bye, who's going to be responsible for taking it down? Again, in PSC 128, with respect to wind projects, there are some decommissioning requirements. But they don't make me sleep real well at night. Do I think they fully protect a county? No. And so we do not want to see a county being put in a position where a project is rolled up and then you're left handing or holding the bag to try to decommission it. And we have seen that happen, not in renewable energy projects, but in frac sand projects. And a county client was literally told, hey, you're the county, you're the best ones to do this. No funding, no guidance, the county had to take on this obligation. We don't want Marathon County to be put in that situation. So within the JDA, we want to make sure we negotiate those decommissioning requirements. And then of course, emergency response. Wind, particularly that have the BESS systems, which is battery energy storage systems, those large batteries that when the power is generated, the lithium batteries hold it before it's released to the grid. Many of you may have heard, there's lots of information and news out there about some of the dangers of BESS. We always are very mindful of what information, making sure it's factual information and promulgated by the National Fire Association to make sure it's objective facts. But there are certainly emergency risks that come with both the actual operating the turbines, the solar panels, and then the BESS. So if something happens at a BESS, or something happens at the facility, your local responders are going to have to respond. What training do they have? And who's going to pay for that training? That's always a significant concern. So just to be able to go through in an agreement and say, this is what is going to be the responsibility of the developer to pay for training, to give us training, to make sure that our first responders are protected and well-trained, and with the resources to do so. Because otherwise, state law doesn't give us that. Without that type of element in a joint development agreement, there's nothing. And we just have to figure it out. I just put a little note on there that those elements, denotes permitted by Wisconsin law that the county can regulate. Note that none of them are. So the county really doesn't have statutory authority to regulate any of those to the extent that we would be asking for in the joint development agreement. And that's why a joint development agreement can be such a powerful tool, because it gives us protection that we can't get by any other mechanism under the law. Okay, let's get down and dirty here in terms of your options. Option number one is you don't intervene in a PSC proceeding. You can negotiate a joint JDA, or you can do nothing. Again, we've seen counties choose to do nothing. I will say that those counties, though, have come at the last minute and then wanted to do something, which we've done. But again, that's why I said earlier, the earlier you can be involved, the better. Option two, negotiate a JDA and attempt to intervene in the PSC proceeding. So again, that's kind of a blended option. You can have those negotiations for the agreement, but then still reserve a right to intervene in the PSC proceeding. Option three is negotiate the JDA, but then actually intervene. So take a more active involvement in the PSC proceeding. That's kind of a blend of option 2 and 3. And then option 4 is, again, the strategy of attrition, litigate and spend a whole lot of money and a whole lot of time litigating the project. The question arises, though, in the beginning, what are we litigating? Technically, we have to go through that whole PSC process and the CPCN process and let that CPCN approval be issued before we can appeal it. So, it may be, if we're thinking, what are our options? Litigation may be too premature to even consider at this point, because is this something we can litigate at this point in time? So please don't think that I'm up here, pushing a JDA because I love renewable energy. Not against renewable energy. I understand we need energy. But what I am passionate about is making sure that local voices are heard. And again, given what we see going on at PSC, given the nature of state law as we have it, a JDA is the best way that we can protect a county. So again, what are some considerations? We can address those significant impacts of the renewable energy project, that whole list that I had up before. We can obtain other concessions that are not otherwise available, such as funding for training of first responders, financial assurances for decommissioning, things of that nature, financial assurances for damages to roads, making sure that the developer submits construction plans, construction schedules, so we know and you can answer to your constituents what is happening with the project. And then finally, avoid reliance on the PSC to protect the county's interests. You may be asking yourself, okay, we're preempted, so where is it in state law that our interests are protected? There's one line in one statute that requires PSC to look at compatibility with local land use interests. I've never seen PSC spend more than 20 seconds talking about that element in their long list of boxes they have to check when they are rendering an approval for a CPCN. And because I used to work at the state, I always feel like I can kind of say this more than other people can. There's a lot of great people who work at PSC who do a lot of due diligence. But when I'm in front of the PSC and I see a 200 megawatt project approved in 38 minutes, that's shocking to me. And you have to ask yourself, are they really looking out for your interest? And if not, who is? And again, that's where a joint development agreement can be a very effective tool to address those impacts of the project. So these we touched on. These are just other considerations. Again, how we're going to mitigate the impacts of a particular project. And so that's really the kind of the hot list of what we will always negotiate within a JDA. These are not set in stone. There's no rule or law that the JDA has to address these. If there are other unique circumstances in Marathon County or the projects that are coming, that we need to address other or mitigate other points of impact, we can certainly do that. But again, this is just a list of the most common items that we will see. One other thing, just as kind of not a forewarning, but as you continue to move ahead, as these projects are discussed, it's always good to identify what the concerns are about that specific project. And again, because there's no PSC filing, we don't have a lot of detailed information. But even at this point in time, you could start looking at the project and start thinking of what the impacts may be that need to be offset. Use your county leaders in any negotiations or any discussions that may occur with the developers, such as your county board chair, your administrator, your corporation counsel. You always want to make sure, or we recommend that you have that point person to speak for the county for the project, because it can be very challenging if there's different messages coming, when you're in the context of either negotiating or if you have intervened or within the context of litigation. And then also use your experts that you have. Use your highway commissioner to weigh in on what the impacts are going to be on your county highways. Use your emergency management director to explain what the real impacts could be if first responders in Marathon County have to respond to a BESS fire. Your planning and zoning director and your county conservationist can also be very helpful in terms of identifying risks that the project may pose, or again, what are the impacts of these projects that you want to mitigate. Your zoning director and your county conservationist can be very helpful to identify those. And final couple words. Again, I know that, or at least I've heard in other communities, we will not enter into a JDA because we do not support this project. And I fully understand and respect that perspective. But again, simply because you are even talking about a JDA does not mean that you support this project. So if you have constituents who say, how can you even be talking about a JDA? Your response may be because we're trying to protect the county's interests, and it's the best mechanism that we feel there is to protect those counties' interests. Again, we see a balance the effective leadership and negotiation with ongoing communication and transparency with your constituents, and with there's a plethora of information that goes into a CPCN application and a JDA. And so have that transparency as you're having those discussions. And then finally, the decision of whether to pursue negotiating a JDA or even a final draft lies with you as the county board. And so if you may have a team of your experts doing the actual nuts and bolts in negotiating a JDA or negotiating any element of a renewable energy project. But ultimately, any sort of agreement or position would have to come to the county board for final approval. Okay. Oh, I froze again. I think that's about it. That's okay. We can. That's a good place to land. Are we on time?
It's magic. It's magic.
Oh, well, there we are, the end. Do you want to?
Yeah,
Okay.
we'll start taking questions. And first, we have Vice Chair Dickinson. Vice Chair Dickinson, please.
Sorry. You might want to get a pen out or a pencil because I got 7 of these. So, number 1, the county passed a resolution 27-7 final vote about local control on wind and solar. And the WCA got that, legislators got that, other counties got that. So I'd be interested to know what your thoughts are about that. But I'm going to continue on with my questions, so please write these down. Number 2, we talk about this agreeable mentality. And when we get to lawyers, oftentimes they're looking at liability. But I'm interested in what the viewpoint of the law firm is to actually fight for what our county wants, given the 27-7 vote, period. Number 3, our comp plan is my focus right now, where we are trying to determine later on in this meeting and next week what our focus is on these systems and how we are to move forward with that. Number 4, why would we join a joint development agreement with a company that hasn't filed with the PSC? Number 5, can and have energy companies reneged on joint development agreements in Wisconsin or other states? If so, what is the point of joining one? And as lawyers, are you only providing a settlement agreement or limited liability agreement, or are you focusing on what our rights are? Number 6, my goals are not your goals. Number 7, you mentioned about physical elements in a JDA. Well, in the PSC, it talks about public safety. Isn't that not a physical element that we can develop some ordinance or some kind of rule to limit these developments? So that's my 7 questions. Thank you.
Thank you, Mr. Dickinson. Andy, maybe if you want to hop in here too, I'll start answering, but I'm sure
I
you want
can
to.
start with the whole question about local control. I don't disagree with local control. I don't disagree with county authority. I've spent my entire 30-plus year career arguing that counties ought to have.
Andy, you turn the microphone on. There we go.
The counties ought to have local control and local authority. I don't disagree with that whatsoever. The reality is that state law tells us that counties are preempted when it comes to regulation of these renewable projects. And so our job as lawyers is to offer counties advice on interpretation and application of the law as it sits, not as what we wish it to be, but as it sits. Frankly, addressing another couple of points, is that as lawyers, we don't have the luxury of a personal opinion. We have the opinion of whatever our clients tell us to have. And so if you tell us, fight tooth and nail to stop this, that's what we do. And so if we're hired to stop something, we will try to stop something. But it's also our job to advise our clients as to risks and benefits associated with taking a particular strategy. And so it would be poor legal advice for us to tell you, say, yes, spend a lot of money trying to stop something without at least advising you of the risks of that particular approach. So I just want to make clear that from a WCA perspective, from our law firm perspective, from every perspective, we believe in county authority to our very core. But we also believe that state statutes has an impact on county authority in this circumstance, and we will tell you what we believe that impact to be. So I just wanted to make that clear.
Rebecca, you want to try to address some of the other questions that were there?
Yeah,
Hold on, okay, go ahead, because there was a question about the JDA. Thank you.
Oh, yeah, I've I've got the questions here. I think I maybe have missed number 6, but, so Andy really answered that, the resolution for local control. I think it's a very good idea, that, if the policy of this county board is to regain, local control, that you do just that. You pass that type of resolution and make your voices heard, in Madison. In terms of the second question of, in terms of what our philosophy is, do we fight for what our county wants? Absolutely. As Andy said, we don't have personal opinions. It's our job as your lawyer to explain options, risks, benefits, and you get to decide. You get to ask us questions, but we don't get to decide, which is why there were 4 options up there. If I had an agenda, if Andy had an agenda, we would say, just go litigate, because that would be in our best interest, but that's not what we want. We want the county to be as protected as much as possible and to further your interests as you state them to be in your policy decisions. In terms of your comprehensive plan, I may have missed a part of the question, but certainly the comprehensive plan is a very important component when we're looking at renewable energy siting. And so you certainly take into consideration where you may want to have renewable energy facilities within a comprehensive plan. The challenge with large-scale projects is that they cover very large areas. So oftentimes it's difficult within the context of a comprehensive plan to plan for these types of projects. The question of why would we do a JDA if they haven't filed with the PSC, that's a great question. I'm not here to say let's do a JDA. All I'm saying is that a JDA is a mechanism if you want to try to protect county interests, if you have those particular concerns. A JDA is a way to do that given the confines of state law. Now, why would we do it before we even have a PSC filing? Because we know enough of what the project is going to be that we can start negotiating it now. And more importantly, when it does get filed with the PSC, we can make sure that that agreement is incorporated into PSC's approval. So then the developer cannot just walk away and, drop its toys and go home. There's some accountability within the context of the 4 corners of the agreement if we are negotiating it, if we have the details even before the filing occurs. Certainly, we want to make sure that there's nothing in that CPCN application that conflicts with the terms of a JDA. And so we would have that reservation within the JDA as well. Have there been any companies that have reneged on JDAs? In terms of renewable energy projects, no. And I will say, you want to make sure that you have a quality joint development agreement, just like you want to have a quality, thorough, comprehensive agreement contract in any situation. So from our perspective, how we anticipate if there may be some sort of breach or non-performance of a developer's obligation is we have financial assurances or promises that have to be made in order for the county, if the county needs to look to those financial assurances to make up for any of those breaks in the promises of the agreement. Another vital element of a JDA is the assignment or the assignability of it. Look at Marathon Wind Farm LLC. That's an LLC that the project is a very large company, national if not international company. Well, all they would need to do is just roll up the Wisconsin LLC and then where's the teeth in the JDA? So what we do is we build into the JDA protections for if the entity either rolls up or it assigns its interest to make sure that there is a party on the hook and it's not the county. So again, that's just another way we can protect our client from a company to renege on a JDA. A question about focusing on limiting liability. Yeah, as lawyers, particular Andy and Evan as the litigators, focus on that limitation of liability. That's a significant part of what lawyers do. From my perspective, yes, we want to make sure that county's exposure to liability is limited, but I look at it also as we want to make sure there are protections in place for the impacts of these projects. So I guess you could say if we're protecting our roads, yeah, we're protecting from liability to have to pay for the roads, but I look at it as we're making sure that our roads are either going to be protected or there's going to be compensation, not by the county taxpayers, if the roads are damaged. So I look at it not so much as limiting liability per se, but limiting the impacts of the project itself. And then certainly we want to make sure that there's proper insurance in place and other traditional mechanisms of limiting liability. But it's not a clean-cut line of liability versus no liability. It's really about what are the impacts on the quality of life and what can we do to mitigate those impacts given the legal restrictions that we face. Number 7, that's the one I didn't, or 6 and 7, and I think 6 was, that Supervisors Dickinson's goals and the county's supervisors and the county board's goals may not be mine. Absolutely. I do not make policy. Andy doesn't make the policy. We are your lawyers. We are your advocates. We are WCA's advocate. We are advocates for counties. So whatever our goals or priorities are, your goals are our goals. We give you the options. We will answer questions. We will explain risk. But whatever you decide, it's our job to advocate for that. So your goal becomes our goal. I think I got them all.
Okay, we'll go to the next questionnaire. Supervisor Sandelsky, please.
Thank you, Mr. Chair. So I've been studying the effects of industrial wind and solar, on farmland for the past 2 years, also involvement with the Farmland First Group. These people that gave public comment during the executive meeting and during this meeting are highly educated on the effects of the energy sources on farmland, humans, livestock, wildlife, and environment. I'm just going to touch on the economic side of this. These contracts are totally one-sided. Landowners who sign these contracts are promised the world. In many cases, companies don't fully deliver. They rely heavily on federal subsidies that come from taxpayers. Without these large subsidies, these industrial wind and solar would be non-existent in Marathon County. When you look at the big picture, consumers are actually paying twice. The subsidized funneled through the federal government from taxpayers, and then their energy bill on top of that. Marathon County does not produce enough wind or sun or actually make these viable to offset the cost of construction maintenance without these large subsidies. So I got an article here about a wind company, Clay County, Texas. They filed Chapter 11 bankruptcy on January 25th, 2026. This was a massive loss to the county and the landowners. To reclaim this land and clean it up, it's going to cost them $89 billion. That's a B, billion dollars. They are left with undertaking and dismantling and reclaiming this property, which is mostly likely going to sink Clay County and its landowners. So if Marathon County decides to sign any JDAs, we must have large sums of money in the billions of dollars with a B for these companies, from these companies, in order to cover their liabilities, because this is not a viable source of energy. And they must be put into a trust fund or an insurance policy to cover any cases such as bankruptcy, et cetera. Lastly, a number of these counties in Wisconsin have already put in place health and safety ordinances reliant to 66.0401. And the closest one to ours was Clark County. They've put ordinances in place for industrial wind, industrial solar, and also battery storage units. And so this is really the only provision, as far as I'm concerned, to protect the people in this matter. I mean, litigation too. So I got three questions. So what happens in the case? I'll just name them and you can just answer them. What happens in a case like this, in a big bankruptcy case? What would happen to Marathon County? And another one is how can we, as far as the battery storage, there isn't really, as far as I'm concerned, I haven't heard a lot about that. Can we regulate that pretty heavily? And the last ones for the JDAs, would we be able to get large sums of money to the county to put in a trust fund for decommissioning if the company goes bankrupt?
Okay.
Thank you.
Thank you, Supervisor. Thank you for all your comments. Those are all very good, and nothing you said jumps out at me that I disagree with. I think all of your points are very good ones, and all points that each of you as supervisors and your constituents have to consider. In terms of, you touched on, in the three questions, you touched on some very important points that we didn't even get to talk about tonight yet. Number one, the local ordinances. So you have wind and solar ordinances now, but again, let's just assume that those are not going to apply to large scale. And so you see other counties that have adopted those large scale regulatory ordinances. That may be a step in the right direction, depending upon how those ordinances are framed. We advise various counties on adopting those types of ordinances, and what we recommend is that you stay as close to that language in 6601 as possible, that you don't have overreach, because then a court is gonna toss it out. Again, Town of Brighton being, that circuit court decision being an exception. And so very, very careful drafting. But the unfortunate part is, even if we have the best local ordinance to regulate large scale, 100 megawatts or more, remember what the Eckert Brothers case says. It says if the PSC issues a CPCN approval, that project will proceed nevertheless. Basically, it doesn't matter what a local ordinance says. So even if we adopt a great large-scale regulatory ordinance, the PSC can ignore it. And Eckert Brothers has is case law saying that that project can proceed nevertheless. So again, I think those are important protections, important steps that you may want to take, but they're not foolproof either, or not soundproof either. Regulation of battery storage, that is a really good point, and one that Andy and I, he's gone. Evan, should we talk about him? No, I'm just kidding. No, we have discussions about battery storage systems and county regulations quite frequently, because if you look at the state statutory definition of a large-scale solar or wind facility or an energy facility, it does not include a standalone BESS system, because that technology didn't exist when these codes were written and when the statutes were written. So if a BESS is connected to a solar or wind facility, then yes, I think clearly PSC has the regulatory authority over that. You could, the county could adopt ordinances to attempt to regulate a BESS that's part of a larger facility. But the real interesting point are these standalone BESS units, because again, we are seeing these pop up all over the state. Kenosha County was the first county to adopt a standalone BESS ordinance. And given the number of standalone BESS that are being proposed, again, given the amount of power that's required for data centers. We are working, WCA is working very hard on what tools can be provided to a county in terms of helping you decide whether you want to have a standalone BES ordinance. So as I'm sure you can imagine, we think PSC is going to say, no, counties, you do not have authority to regulate standalone BES, but we think that there's a really good legal argument that you do. Way better legal argument than the large-scale facilities as a whole.
Administrator Leonard?
And sure, just to add to Rebecca's point and your question specifically to BES's, in your most recent code revision, you look for some light reading, section 17.409 is the battery energy storage system ordinance that the board adopted.
And I did miss your last question in terms of the decommissioning financial assurances. The stories of that community that you referenced that has to now account for that $1 billion cleanup are heartbreaking. And so what can we do to protect the county in the best way possible? In terms of a bankruptcy scenario, I'm not a bankruptcy lawyer, but we would require a financial assurance as part of any agreement that would be held in trust. It would be separate monies, if you will, a separate pot that would be committed to any cleanup costs if they didn't perform. Now, I can't give you an exact answer on how that comes into play with a bankruptcy scenario, but I think that is the best protection that we have under the law as it stands now to make sure that there is some pot of money available for decommissioning if they file for bankruptcy or go belly up. Or walk away. That's the other risk. When we're talking about a local LLC or a Wisconsin LLC, who's to say that they're not just going to close up shop, leave all the facilities there and move on?
Supervisor Seibert, please.
Thank you, Chairman Gibbs. About 25% of Marathon County is in townships. How can we get those townships involved? If the townships want to become a part of this, what would it take and how would we do that? I mean, they've got to be protected. That 25% has a lot of stake in the game.
Sure.
So how, I mean, would we be stronger if they were jointly joining?
That's a great question, and a frequent question that counties and towns will ask. Is it better to have the discussions with all of the county and town on the one side of the table and developer on the other side of the table? And it really depends on what the county's goals are. I mean, certainly you want to continue to be good partners with the towns and work collaboratively. And that may be, we do want to negotiate an agreement, all of us together. In other counties with other counties we've represented, we've seen scenarios where sometimes county and town interests will diverge, and then it's best that we go our own path. Or sometimes town interest, with multiple towns, all the towns won't be on the same page. And then that can create issues for the county in that process. So it really depends on what the circumstances are with those 5 townships. But certainly towns have a role in this process. And oftentimes towns will have their own legal counsel because, we are legal counsel, obviously here's WCA, on behalf of WCA, but when we represent a county, we're the county's counsel. We are not the town's counsel. So that's another consideration too in terms of how you want to handle those discussions.
Supervisor Marash, please.
Thank you, Mr. Chair. I have 7 questions too.
Okay, I'll get ready.
All right, so when a landowner signs an agreement with one of these entities, does their zoning change? Does it change from agricultural to industrial or commercial? So just my concern for the landowners is they might be bamboozled into thinking they're getting this money from this lease agreement, but then in reality, their taxes go up because it's a utility. I'm not sure if that's true or not, so that's why I'm asking you. My second question is, what power do the neighbors have when they become negatively impacted by one of these wind turbines that's close to them, when they start having health issues or, what agricultural issues? What can they do about it, and how do they go about doing that? The third question is farmland preservation credits. We have farmland preservation here. So if a landowner signs on to a lease agreement, do they still qualify for that credit? The next one, when you were talking about having the ability to intervene in PSC proceedings, how is that successful at all when the PSC still approves every project that comes across their desk? That's, and then 5, how long does the joint agreement last for the whole life of the project? Or is there just a certain amount of time? Usually aren't they like 30 years? These agreements are for about 30 years. So far, in my estimation then, there has not been any joint development agreement that has reached full maturity so that we know that they actually were successful on every count, right?
Yeah, that's true.
So that's kind of a question answer already. So
Okay.
you can,
But no, there are strategies that we can implement too. In fact, I'll start with your last question. The term of a JDA will indeed be for the life of the project, and how we define life of the project is initial design, pre-construction, construction, operation, ongoing operation, and then decommissioning. So all of those different life phases of a project are covered by the JDA. Oftentimes, the life of the project will be described in the PSC application, in that CPCN application, so we can tie the terms of the JDA to what they have their approvals for from PSC. So that's one strategy we can use. And again, it's so important to make sure that there's continuation of responsibility. So if developer just walks away or sells its interest, to make sure that there's somebody else on the line besides the county. So that's another consideration. We're talking about the life of the agreement. And then stop me if I missed any of the questions. In terms of the landowner agreements, we obviously don't represent landowners, so I am not privy to a lot of these agreements. The ones I have seen, I would not advise a client to sign. Now, that is not the case for every landowner agreement out there. Every landowner, it's their right to negotiate, enter into that agreement. Many people say, this is my land. If I want to lease it, it's my choice. That can be a very hard discussion to undertake. So in terms of protections within those agreements, I can't speak to, specifics. But what I can say is the ones I've seen, I would not advise a client to sign. And I hope that, landowners do use good due diligence in reviewing those agreements. If neighbors have health impacts or agricultural impacts or any impacts from these projects, what can you do? Within the statutes and within the 4 corners of the law, if you will, there's no specific process. You could attempt to bring some sort of legal claim for damages, go a litigation route. We always want to make sure that there are point of contacts. And actually in a JDA, we will build in obligations for if a complaint is received, it has to be answered in so many hours or days or whatnot, just so we know somebody to call. Or you as a representative can give your constituent, like, hey, this is the point of contact that we've been given. That sometimes can help a lot. But depending on what the damage or the harm is, that's really going to drive then ultimately what their remedies might be. Farmland preservation, another great question. in terms of the county's farmland preservation program. Another state agency besides PSC and DNR that is involved in the state process is DATCAP, the Department of Ag, Trade Consumer Protection. And so they're really the agricultural oversight at the state level. They will get involved and deliver a report on agricultural impacts. Most of them are oftentimes very glowing, in terms of what the agricultural impacts would be of a project. And I think many of us may understand why that may be, but just a heads up that DATCAP is involved, but DATCAP is a state agency, so if the county can have a seat at that table to talk about agricultural preservation and agricultural conservation, that's a good thing. In terms of losing credits if you lease your land, that I don't know. I've heard DATCAP say, no, you don't. But if you look at the legal requirements for those tax credits in Chapter 93, I'm not sure how you would not lose them, but that's really up for the landowner to decide. Your other question about a rezoning of your land if you enter into one of those, the host agreements, by virtue of entering into that agreement, that doesn't result in a rezone. There may be something in that agreement that requires an owner to seek a rezone, but by virtue of entering into that agreement, that does nothing to the zoning classification itself.
Thank you very much. I just had one more.
Sure.
How much, so let's say the county wanted to go into a joint development agreement, what would we be looking at for cost for that?
It depends on which option you pick. Again, the most expensive option is the option of, the war of attrition. And so what we always discuss with counties and county boards is, what are your goals? And then we will try to give you the best estimate of cost for those goals or what that option is. Another provision that we always require in a joint development agreement is a reimbursement of professional fees, including legal fees. So we've been, I don't think we've not been able to recover attorney's fees in any of the JDAs that we've been able to assist counties with. And again, our position is we wouldn't be here but for this project. Why should the county have to incur legal fees?
Thank you very much.
Mm-hmm.
Supervisor Wilhelm, please.
Thank you, Chair. When we were first notified about this is after people started signing contracts. And I sat in a meeting and they were talking about contracts and disassembling these. They actually had an end of a contract that if we do not get to it within a year, you can disassemble this yourself. And what I was wondering is, could we have taken a proactive approach and had an ordinance that they would have had to have notified us before they went to residents in the county for a project of this size?
Oh, the company, the developer would have had to approach the county first. Andy, jump in here if you think of something. I'm not sure what your statutory authority would be to have that type of ordinance requirement. It would be a challenge. It's always a great thing when folks hear about projects even before those people are out in the community. That has happened with some of our counties, that like somebody will just hear about something and then you can start dialogue with the company to try to have that communication. But in terms of an ordinance, I'm not sure what the statutory authority would be.
The reason why I ask is that they sent high-pressure salespeople out, and most of the people did not read the contract, or they read the first few pages, and then the back pages were negating what was happening in the front.
Mm-hmm.
And some of these contracts are horrible. And people sign them without, because they had a sales guy there, hey, buddy, we're going to do this. And that's why I was just wondering if there was something that we could do so you could at least put the information out that, hey, seek legal counsel if you think about doing this, just to try to protect people in the future.
No, and I think it's noble to try to protect those constituents from, predatory salespeople. But again, in terms of a statutory authority, I'm not sure there is anything that the county could adopt.
Thank you.
Agree.
I agree.
Any other options you can think of?
I mean, it's an education issue. It's an education issue. What we're talking about is folks that don't have an understanding about scope, scale, money, issues, concerns, and I get it with the high-pressure sales, that happens. So as a county, can we educate the public about what these projects are about, what the county's role is in these projects, what their consideration? Sure, we can do all of that. Are we going to have an ordinance on the books that requires advance notice? No, because what's the penalty for violating that ordinance? We don't have jurisdiction over the project in the first place. It's a PSC issue. So realistically, I think that we have to decide as a county, what type of education effort are we going to have with our communities to make sure everybody's aware of what's happening?
Okay, Supervisor Robinson next.
You talked about many of the tools that are available to the counties. Where does a moratorium for a time certain fall within that toolkit?
That's a great question, one that we also receive a lot. It can be a useful tool if you have a legitimate basis for imposing that moratorium. And I don't know the details of your comprehensive rewrite or where that is, but that would certainly come into play when deciding whether to do a moratorium. The obvious question is to a moratorium on what? There are statutory restrictions on the types of moratoria that a county can implement. And so you'd have to look very closely at the what is that moratorium for. It cannot be what is defined in the statutes as a development moratorium. So it would have to be carefully crafted to make sure that any moratorium complies with the statutes.
If that moratorium were to identify health and safety?
From a legal justification standpoint, I would highly recommend that you have more than just for public health and safety. You really want to dive deep into what are the particular issues of concern that justify putting this moratorium in place, and not go beyond the generalities of health and safety.
Next, we have Supervisor Boots, please.
So I was not aware of the intervene aspect, so I kind of was jotting things down here. So my question would be this. If we went into a JDA, and basically going off what I actually had this jotted down too, a moratorium, because we put in the JDA saying that we'd like more time for community engagement, so we know what the actual wants and needs are for the JDA. And then if that doesn't go through, let's say we don't agree, we still could intervene at the PSC, correct? I don't know what that looks like. When you say intervene, what does that look like? Is it just attorneys in there looking at it? Is it we have individuals? Could we bring state reps? Could we have anyone at that PSC?
Yeah, so great questions. Let's start with that one. What does that look like? So part of the very detailed PSC proceeding in the statutes includes hearings in front of the Division of Hearings and Appeals. That's kind of the court arm of state government. And so there's one judge at DHA who's assigned to all PSC cases, Judge Newark. So anytime there is an action or a CPC, an application filed of this nature, there will automatically be a DHA hearing opened as well. So when you intervene as a party, you get to participate in that hearing as a party. So you have now become a party to the court case. So think of it as like a court case. So an intervener can participate in taking witness testimony, submitting evidence, doing cross-examination of other expert witnesses. There is a far more detailed involvement in the particulars of the case. So the evidence of the case, what is the science behind the application? Are we going to challenge the assertions in the CPC and applications? Is it faulty science? All of those, very detailed components. So when you intervene, you can actually bring witnesses, you can cross-examine, et cetera. In terms of, is it like, who do we have at that intervene table? It would be the county or the municipality who would move to intervene, and it's a motion that you have to bring under the statutes, and then it would either, Judge Newark would either grant or deny. There are provisions in the statute that protect counties to intervene. So if the county chose to intervene, it would be extraordinary if it was not allowed to. Now, oftentimes private parties will try to intervene. You know, me as Mary Smith property owner, I may want to intervene, and then I have to make my case to Judge Newark. And then he gets to decide if I intervene. But again, for certain municipalities, there's a higher threshold of right to intervene.
So with that said, I guess my question to that is, so if you go through the JDA, you do the intervene process, Public Service Commission, from what you're telling me on here, is pretty much a rubber stamp at this point, which is not okay. I mean, that's not their job. They need to look through these a little closer in my mind, but doesn't that set us up for a better possibility of litigation if they're not meeting any of our needs? Doesn't
Exactly.
that set us up for a better case?
So oftentimes with other counties we've worked with, I can say that the choice of intervening is threefold. Number one, they want to have a seat at the table. They want to have their voice heard beyond submit a public comment, which I've actually heard Judge Newark say the commissioners don't read the public comments anyway. Bless his heart. So oftentimes people want to have a more active voice than just through the public participation standpoint. So voice at the table, to be able to submit actual evidence in order to further their position. In the circumstances we've been involved in have been to challenge the science that is brought forward to justify the project, to challenge some of the, or the lack of decommissioning responsibilities that PSC was requiring. So in those types of situations, the county wanted to make their case. Interestingly, in one situation, the county did not intervene, but we were negotiating a JDA, and again, there was a whole lot of community opposition to the project. The county board decided we need to protect the county to the best of our abilities. So we were having dialogue and negotiating the JDA. And then suddenly they stopped returning phone calls. And Andy and I kind of chuckle about this, like, what? They just went dark completely. Well, they knew that PSC was going to be rendering its decision before we did. And so the night before the PSC hearing, the agenda hadn't even been posted. They post like the night before. So unless you're a party, we kind of can guess now based on timing. But in that case, the night before we sent a letter and said, hey, PSC, we did not intervene because we were told that we were going to negotiate a JDA. And that was a really quick lesson on the extent to which we are going to use the intervention process. But fortunately, what we did, we sued the PSC on the back end and said, PSC, you did not do your duty in protecting the county. Remember, I said that one line in 196-491 that requires a finding that the county land use is not going to be negatively impacted. We said, look at your record. Your record does not substantiate that decision. And so your decision was wrong. And suddenly they called. They returned our calls, right, Andy? So the PSC decision was not overturned. However, it did start the negotiations back again, so we were able to achieve the county's goal. That was a very long answer to your one question, but let me just say one more thing. The other number 3 reason counties may want to intervene is to do exactly what you said and create the record. So if there are particular aspects of a project that I think are really ripe for challenge, we may want to intervene in order to get that evidence into the record and then try to challenge the decision later.
And can I have a follow-up quick?
Go ahead.
The question then was, Brighton, obviously, that was under 100 megawatt though, correct?
I believe so, yes.
Has there been any successful litigation against anything over 100 megawatt?
No.
That's it.
There is a town in one of our northwestern friend counties that a township, this was several years ago, put up a really good fight, and the developer picked a different site. And so that oftentimes will be used as an example of a win, but it's not really a win because they literally went like down the road. Which, that it may happen. We never know what's going to happen. And it's an extremely unfortunate part of the way that the state law framework is set, that it really limits and quiets the ability for folks to have their voices heard.
Thank you.
Next, we have Vice Chair Dickinson.
Thank you, Mr. Chair. So I'll just make a couple comments. One, in fact, you did make the recommendation move forward with the JDA in your PowerPoint as the best path forward. So please just kind of acknowledge that there's not much we can do the way you stated it, and the JDA is the best way to kind of like kludge those things together. Number 2, agreeing to a JDA in actuality is agreeing to allow it. It's a hedge bet. So you're not fighting it, but you're going against your principles to say it's the best option. So let's agree to that. Number 3, you mentioned, again, I'll repeat this. You mentioned, not me, that physical elements like public health. Who's speaking?
Go ahead, never mind.
Thank you. Thank you very much. I appreciate that. You mentioned physical elements like public health and safety being put into the JDA. But then you said we can't fight against them before the JDA. I don't understand that. You did not explain that, you nor Andy. So Jason Wilhelm talked about permitting. No one gave us guidance on that. No one has ever said that ahead of the issue. Andy said it was an education issue. So the way I look at that is, could we not have put in place permitting ordinances to say that anyone doing such has to register with the county and then tell local municipalities about that? Is that not true? So those are my questions, because honestly, I understand what you're saying on a state level, but I don't really think you're understanding the impact locally that we're feeling. Thank you.
Andy, you want to address these questions?
On the permitting question, I thought I was pretty clear that I think it's highly doubtful that you could have an ordinance requiring that sort of permit requirement on a solicitation. Because I'm not aware of any other community doing that, and I've not researched it, but to me, that would be problematic. I'm not going to argue with anything else that was said. It is what it is.
I will say, please, let me clarify. I am not saying do a JDA, it's the best thing to do. You don't even have an offer to do a JDA in front of the county. We're talking philosophically here. There's 4 options in the PowerPoint for a reason. Those are 4 options that we have identified in working with other counties. So if you were to get an offer to do a JDA, if you had a proposal in front of you, if you had someone come to you and make that offer, it would be upon the county to decide whether even to engage a dialogue or weigh your risks. Then Andy and I would look at the agreement and assess the risks for you. At that point, we may not recommend you do a JDA. we don't get to decide. I am not saying you should do a JDA. What I'm saying is oftentimes a JDA can be a useful tool to offset the impacts of these projects that right now they're 33-0 and being approved. So it is a tool in the toolbox, and in our experience has been an effective tool to use to offset the mitigation or mitigate the impacts of these projects. Hopefully that's clear.
Supervisor Crowell, please.
Thank you, Mr. Chair. I wanted to actually take a 30,000-foot view and ask a question. It was something that Annie brought up at the very start, and that there has been a decrease in energy demand across the state. And I'm curious why these utility companies are pursuing solar and wind in general instead of going to something like natural gas, coal, biomass. I guess I just wanted to see if there's anything like in the PSC filings.
All right, I'm not an energy expert. I want to make that clear. So I am reporting to you what's been reported to me. And so I've listened to analyses by the Wisconsin Policy Forum. There has been Wisconsin energy and power experts that have expressed this. And so when I say to you, there's been a decrease over the last 20 years, that's based on the statistics generated by those entities. And my understanding is that with the power plants, if you will, that have been taken offline, it would cost so much to get them back online that renewable is an opportunity to get some more energy onto the grid in the most efficient and economical way possible. Plus, I think everybody's aware that there were huge tax incentives for these renewable projects. And so you bring the federal tax code into that, which is going to bring investor money. And so, again, my understanding is that there are economic incentives that align with the renewable push as opposed to those other sources.
Also, one other thing I'll add on, and this is often referenced at the PSC, there is a provision in our statutes that says it is a statewide policy to encourage renewable energy. And I'm not sure when that was put into the statutes, if folks really understood the magnitude of that statement. But again, it's in the statute that Wisconsin's policy is to pursue renewable energy.
And just to follow up, Mr. Chair.
Go ahead, please.
I'm curious if there's any difference in a permitting process between like a natural gas plant versus solar energy. Are the rules the same of what a utility has to go through?
My understanding is no. I think that from a regulatory perspective, a coal plant, for example, would require a lot more regulatory approval than would a solar facility or wind facility.
And if I could just follow up to that, we actually had I had a similar question yesterday from a county asking, do the same rules apply to nuclear? And no. So Chapter 196 of the statutes apply to all sources of energy. But there's specific provisions within 196 that are particular to solar and wind. The CPCN application process that I mentioned, that is required for all different types of power generation. But Andy's right. Each different type has different regulatory particulars, if you will.
Just a side note, several of us are on the NACO Rural Energy Academy, and we heard from national leaders that nationally, the energy consumption over the last basically 20 years has stayed flat. Even though energy demand has increased, and I say that tongue in cheek, because one of the things that we've done as a nation to reduce energy consumption is lights, LED lights. LEDs have significantly impacted the demand for electricity. But they also are now projecting, because of data centers, that the demand for energy is going to go up 7% per year nationally for the next 4 years. So it's really significant. Now, one can argue what's the thing that can be put online the quickest. They're saying that regulatory and permitting for nuclear is about 10 years. coal and natural gas, probably less, but solar and wind is the quickest. Not commenting on whether we want whichever, but it's just factual information. We next have Supervisor Poole.
Thank you, Chair Gibbs. Just a question for more clarity on the PSC's authority. You've said these proposals usually breeze through 33 and 0 for solar, no real rigorous EIS studies, and the whole process sometimes just done in 38 minutes. I know there's statutes related to this, but how much of this is at the discretion of the PSC's authority in their approach? And would, for instance, like if they chose to change their approach, maybe had a change in leadership at the PSC, could they develop a more rigorous review process for these proposals and give more weight to local concerns and other concerns, and actually maybe even say no to some of these proposals? Is that correct? Thank you.
Yes and no. It's a very lawyerly response. The PSC, even as they are moving through their decisions very quickly, they do a very good job of making sure all of the statutory boxes are checked. And yes, you have 3 commissioners out front, but you have an army of people working behind them too. And there are many, many good people at PSC who work really hard to get thousands and thousands of pages of information condensed down for the PSC to actually make their decision. And so, again, PSC does a really good job of making sure they're checking boxes that they have to as to the statutory requirements. If they don't do that, they open themselves up to legal challenge. But the real heart of the issue from my standpoint is, are they spending enough time on these? You know, again, the hearings that I've seen, they're like fly through these. I will say the last hearing that I attended, PSC spent more time talking about local concerns than I've ever heard them talk about before. So maybe there is a trend in a direction of consideration of local concerns. And they actually also talked about, you know, whether there is a development agreement in place and so forth. So I don't want to speak for PSC, but I think they would say, given the volume of information they have to go through to make their decisions, they're doing it as best they can. But it would, from my standpoint, it would be nice to have better assurances that they're taking public input into greater consideration. And how we publish that, I don't know.
But they could, if they chose, have a more rigorous process and actually say no to some of these proposals if they put more weight on things like local concerns. Is that correct?
Given the statutory framework right now, there's no, obviously there's no local approval requirement. So if PSC was going to deny a CPCN application based on local input, that local input would also have to be substantiated by evidence. So the PSC could rely on that in making their decision. But again, it really is a function of what our state law says. So it's not all PSC's fault. You know, they are operating generally under the statutory requirements. It's just a question of how much they're looking at certain particular issues. If we had some sort of, you know, administrative rule change that gave more authority or gave more weight to local input, I mean, that would be fantastic, because then PSC would be required to check that box.
Okay, thank you.
Okay, Supervisor Sandalski.
Thank you, Mr. Chair. So Alliant, I kind of got trust issues with them because I believe it was a month ago, last month, they were supposed to come and do a presentation for the executive committee, and they never showed up. So I got trust issues of whether they'll even hold up their end of the bargain if you signed a JDA. And some things we could do in place, we could put in our comp plan, like something like promote natural gas, clean coal, and nuclear. And also one other concern you have is with the PFAS. We've been talking about the PFAS a lot. And when the turbines spin, they shed PFAS into the soil, and then you're gonna destroy your well water, your rivers. I mean, it's another addition of PFAS to the environment. So I mean, there's a lot of environmental issues with it, but that's one of them since we were on the PFAS. So I guess that's about all I got. Thank you.
Rebecca, I do have, so that was the last individuals that have requested to speak. I do have a question. So we have obviously different projects that are in different phases in the county. One being a public utility and an operator being Alliant Energy, another being just a public developer on a separate project that probably is never going to be a operator. And then another entity, I believe, out in the town of Easton is at least in the negotiation phase with potential land leases on a solar project. Is there different concerns or different negotiations or different concerns and risks with a Alliant Energy operator project versus a developer project that is out of country or even out of state?
That's a great question. And oftentimes in these siting applications or the initial CPCN applications, you won't see the publicly regulated utilities bringing them forward. Here, obviously, we have Alliant. Xcel has one in St. Croix County. So there is a different rule book, if you will, because public utilities are heavily regulated. And so when working with a public utility on a development project, oftentimes they will use their heavily regulated nature as a basis for not making certain concessions. And then it becomes a matter of, well, point to that. Where in the statute are you prohibited from agreeing to this? That type of discussion. The good thing about a public utility, and Andy, jump in here if I'm misspeaking, there are certain requirements of a public utility for decommissioning that they have on them to begin with. And so we may have greater protection from a decommissioning risk standpoint. Whereas a private developer, they can roll up shop and go bye-bye. But my understanding, again, I'm not an insider, but my understanding is that most developers will ultimately sell to the public utilities.
So ensuring that there's transition of the JDA, if there's a JDA in place, that there's legal consequences and the flow to the eventual new owner and operator.
Absolutely. I would say that of all of the important elements of a JDA or any agreement, when we're in the county's shoes, that assignability is one of the most important. Because if we don't have it follow the next party, everything else becomes meaningless.
Okay, any other questions for either Rebecca or Mr. Phillips? If not, I want to thank both of you.
Thank you.
And a great presentation, great education opportunity. Thank you. We will go back then now to the item 8A, standing committee chairs or designees. Any reports by standing committee chairs or designees? All right, seeing none, we'll move on to item number 8D, introduction of the Homeless Response System Coordinator. I will turn it over to Administrator Leonard, please.
Thank you, Mr. Chair. And Megan is on her way up here, but before I jump into how excited we are to have Megan join, I just want to do a little bit of level setting again to go back to, well, why she's here. So last year, the board made some important policy decisions relative to the county's role with respect to homeless response, our response to the unhoused population. And succinctly put, you entered into a task force with the city of Wausau to learn more about the challenges facing our community and what are some areas where the county could, working with the city, better define what our specific roles and responsibilities would be. So one of the things that came out of that task force was the direction to county staff through the budget to create a new position, Megan's position, the Homelessness System Response Coordinator. So what does that mean? And I'm not going to get into and do a long presentation. I know you still have to hear about some highway system, highway shop work we're talking about, but succinctly put, the position was put in place to, again, strengthen partnerships within all of the entities that work in that space, improve information sharing and service navigation, one of those things being the development of a key performance indicator dashboard. And then, as I said before, support the development of that long-term strategic plan to address homelessness, again, in partnership with the city of Wausau. So suffice to say, we did a recruitment following your adoption of the budget, and very, very excited to announce that Megan Barnett has joined the team. She started on Monday, a very calm day here in Marathon County. Nothing was happening, literally and figuratively. But Megan comes to us with more than a decade of experience in public health, most recently working with Sanford Health, Marshfield Clinic Health System, a lot of skill and experience in the substance use realm, which, as all of you know from that joint task force, very intimately intertwined along with mental health challenges that this population is facing. So again, thrilled to have Megan join the team. She's gonna be working with our health officer, Caitlin, and Amanda to really address this. And really first, we're gonna start with immersing ourselves and Megan immersing herself in all of the various entities that work in this space. So with that, I'll invite Megan up and she can say just a brief, you have like 20 minutes to talk about yourself, I think.
Sounds good.
Yeah, go ahead.
Thank you, Administrator Leonard. I just wanted to take a minute to say thank you for allowing me this opportunity. I am incredibly grateful and humbled and frankly excited to get to work. I have a lot to learn from all community partners. I am a transplant from Spencer, so I am not new to the county, but I am new to the area. So I'll be eager to do all of those meet and greets in the upcoming weeks. I also just want to commend all of you for taking this public health issue seriously and allocating resources to make sure that we are doing our due diligence to protecting our own community members. So with that, my commitment to all of you is to make sure that you are all up to date with what the task force and myself and the rest of the entities are doing to combat this issue in the community. So thank you all so much.
Well, thank you and welcome.
Thank you.
Absolutely. If there's not an objection, I'm going to take a 10-minute recess to allow people to stand. And so we'll stand in recess till 10 minutes after. Thank you.
I think I'm gonna lose badly.
Yeah, you're not gonna do well.